This is Trial Transcripts Exposed by Crime in Court with Heather. Raw courtroom reads with my commentary. Let's dive in. Hey everyone, welcome back to Crime in Court with Heather. This is Trial Transcripts Exposed. We are reading through the entire trial of the Menendez brothers' retrial of the homicides of their parents, Kitty and Jose. It took place in 1995 to 1996. We just started 1996. So we completed, let me look at my thing. We've been through, I think, 3 months worth of trial now. Anyways, however long it's been, we have been chugging along. We're going a lot faster now. We're getting through half days at a time and doing more per week. And for whatever reason, this isn't coming up. Okay. So it started in October of 1995. Do we have a date? 11th. October 11th of 1995, we began. We have just now hit the threshold. We're right about the middle part of trial, and we have completed December. So we've moved on to January, and this is January 3rd, the half day, the second part of the day, I should say, of January 3rd, 1996 is where we're continuing. Erik Menendez is still on the stand. He's being grilled by Mr. Khan for the state. A lot of questions about the night of the crimes and what happened, and he's grilling them on that. So we're going to continue with that in 1 second. I just want to make the announcement that there have been some member perk changes. All of them are with you guys in mind for more interaction, more recognition, things of that nature. So check out the perks if you haven't already. And while we're on that, founding Justice Insiders, anyone who joins from now until June 30th becomes a founding Justice Insider. You get Justice Insiders, and founding Justice Insiders will get their names read or announced at some time in all of my videos, every video. That's one of the perks. So thank you to Toyota Girl 67, SLB 29488. May the force be with you. 4313, Jessica Wienand 6079, Mrs. Apples with a Z 2007, Butler 89833. Thank you all for your founding memberships. Brooke JF, Jen P 773, Boom Chicka Wow Wow 1, and Kendall B 5757. Thank you for your founding memberships. And you too could have your name read off if you join between now. Actually, anytime. But you will be a founding member on the Members Wall of Fame, and you will be announced as a founding member when your name is read. So if you join between now and June 30th. All right, let us get to our presentation here. So, like I said, we left off, Erik's still on the stand, and we're going into our afternoon testimony with Erik. All right, so the court says, everybody is present. Are we ready to proceed? Mr. Levin says yes. Mr. Khan says yes. The court says, let's get the jury out, please. They enter. And the court says the jury is all back, and the defendant, Erik Menendez, is still on the witness stand. You may continue your cross-examination. Mr. Khan says, thank you. Mr. Menendez, when you were at your home picking up the shotgun shells before you went to get rid of the shotgun, did you count the number of shells, the shotgun shells that you picked up? No. Did you make an effort to ensure that you picked up every shotgun shell that was inside the room? No. When I left the room, I thought that there was probably some that had bounced near my parents. What made you think that there were probably some that bounced near your parents? Just that they could be anywhere in the room from what I gathered, and I didn't want to go near them. And so I just thought that there might very well be some there, but I wasn't going to go check. Now, the reason for picking up the shotgun shells is because you didn't want the police to find shotgun shells with your fingerprints on it. Is that correct? Yes. And you're saying that you believe that there might have been shotgun shells with your fingerprints on them near your parents, and you did not want to go near your parents, so you didn't retrieve them? Right. What I'm saying is that I was picking up the shotgun shells on the likelihood that some of the shells might have my fingerprints, but I wasn't going to go near my parents. That was more a concern to me. Are you saying that you recognize the possibility at that time that the shells, if there were some near your parents, might have had your prints on them? Yes. And even with that knowledge, you were unwilling to go near your parents to look at the shells or look for the shells. Right. Why? Because it was a horrible sight. I didn't want to touch them. I couldn't be near them. I could barely stand to look in their direction. The idea of going near them and looking around them or under them is not something I could have done. So today you realize that you just so happened to retrieve every single shotgun shell that was in the room? Objection, irrelevant. Overruled, says the court. Eric says, I witnessed it when I read it in the paper. I either read it in the paper or saw it on the news. I believe I read it on the paper that all the shells had been retrieved, and I remember being surprised because we hadn't gone near them. I'm surprised that all of the shells were the ones that stayed in that area of the room. Now, when the police arrived, what did you do after the first telephone call to the police, the first 911 call? I know that I called my coach, Mark Heffernan. Well, let me go back. I'm going back to the time when you first returned from dropping off the shotguns and you got back to your home, and Lyle Menendez called the police at that time. Is that correct? Yes. Now, what was the call from your brother to 911 or after your call to Mark Heffernan? Was that call from your brother to 911 before or after your call to Mark Heffernan? Sorry, I read that wrong. I believe it was during, perhaps after. I'm not sure. It wasn't before. I know that. You listened to that 911 recording here in court. Is that correct? Yes, I did. And you heard yourself scream on that recording. Is that correct? Right. At that time, I believe I was in the foyer. So you weren't talking to Mark Heffernan on the phone while you were screaming in the Lyle 911 call, were you? No. All right. So did your call to Heffernan come before or after your call to your that your brother did to 911? It must have come after or at the very end of it. What was your reason for calling Mark Heffernan at the time? I felt extremely empty and I wanted a friend, and Mark was the first person on my mind to call to be with me. Well, your brother was going to be with you that evening, wasn't he? Yes. Why did you feel that you needed someone other than your brother? I'm not really sure, other than what I told you. Well, you told us that you love your brother very much, is that correct? He is the most important person in the world to me. In fact, you had just committed this killing along with your brother, is that correct? Yes. And yet you wanted a third person to spend time with you that evening. Why does that matter? I wanted the comfort of Mark, or I'm not sure. Mark. I know he was the first person that came to my mind. Yes. Did you want a witness to your display of emotion? No. At that time, the police were already there. I mean, there was no reason for Mark to come over other than just me wanting him there. The police were there when you called Mark Heffernan? No. Lyle was calling the police. The police were going to get there before Mark was. Mark lived in Brentwood. And after you called Heffernan, was there a delay before the police called and told you to come outside? The police called and told us to come outside. Was there a second conversation? He didn't answer the question. Was there a second conversation with the Beverly Hills police that night after the call to 911? I didn't know that. I thought the police had told Lyle to come outside in the 911 call. It's your understanding as part of the 911 call, the police told Lyle to come outside. Is that correct? That's what I had thought. Lyle said that he had talked to the police and they wanted him to come outside. I assumed it was when he was talking to the police in the 911 call. Well, how much time elapsed from the time he first got on the phone to 911 to the time that you left the residence? I don't know exactly what time he got on the phone call, 911. I know that I was in my room using my phone to call Mark, and I believe he came into my room and said, "Let's go. The police want us to go outside." And then we went outside immediately, so less than a minute. So he came to your room and said, "The police want us to go outside." The police, I believe that's what happened. He came to my room and said, "The police want us to go outside." So your room is upstairs on the second floor? Yes. And you and him walked out of the house together. Right. You walked across the second floor balcony to the top of the stairs? I guess so. You walked down the stairs and went outside with him? Yes. And during that time, did you say to him, "You know that, by the way, our parents weren't armed"? No, that's not what was on my mind. Were you thinking more about evidence at that point? Objection, argumentative, overruled. Erik says, "At that point, I was just thinking about what was going to happen when we got outside and confronted by the police." Uh-huh. Were you thinking about what kind of demeanor you're going to show when you saw the police outside? No. And what did you do when you got outside? The police officer told us to get down on the ground, spread out our bodies so that he could search us. Do you recall the testimony of Officer Butkus here in court saying that you were immediately saying, "I can't believe it"? It's irrelevant and also hearsay. Overruled. The witness says, "Right, I must have said that 100 times that night." Uh-huh. Not only did you believe it, you had done it. Is that correct, Mr. Menendez? I had done it, and that's what I couldn't believe. I just couldn't believe it had culminated to this point. Did you hear the testimony of Officer Butkus that sometime while you were saying, I can't believe it, you were looking up at him? Is that correct?" Mr. Levin says, "Objection. It's irrelevant to what another witness testified to." Sustained at this point. It is irrelevant. Were you looking up at Officer Butkus during the time period when you were saying, "I can't believe it"? I did not talk to Officer Butkus. I remember looking down the road and seeing the ambulance and knowing that the ambulance wasn't coming. And I remember the emotion of what? Of that sight. The sight of what? The ambulance not coming into the house. And you found that to be emotional? It was. Why? The fact that the ambulance wasn't coming to the house meant that it was too late for my parents, and just in a way, I wanted them to come into the house. Mr. Menendez, you knew it was too late for your parents when you were picking up the shotgun shells instead of checking their pulse. Is that correct? That's correct, yes. And we're talking about how much later now? Close to 2 hours later. He could still be in shock. And you're telling us now you had an emotional reaction to the fact that the ambulance was not driving up the street. Yes. Did you check their pulse then, Mr. Menendez? I'm not saying that any of these emotions make sense or made sense to me at that time. But I felt sad that the ambulance wasn't coming into the house. I didn't want my parents to be dead, and the fact that this was further evidence that they were in my mind emotionally, it was a great pain. And then how long were you kept around the vicinity of your residence before you were taken to the police station? I don't remember how long. Can you give us an approximation? No. How long did you stay at the police station? For about 5 minutes before the tapes were made and about 5 minutes after, so however long the two tapes combined came out to be. Uh-huh. And do you recall being in this? He keeps doing that, like, uh-huh, like he doesn't believe his answers or something, like he's looking down on him, mm-hmm. Do you recall being interviewed at the Beverly Hills Police Department at about 1:20 in the morning? Yes. And after you met with the Beverly Hills Police Department, you left the station with your brother and Mark Heffernan, is that correct? Yes. The three of you left together? Yes. Now, was it your intention at the time that you were speaking to Sergeant Edmonds to suggest that organized crime was responsible for the killing? No. Now, you were aware at that time of your father's dealings with Noel Bloom and Morris Levy? I don't think so. I think at that time I knew that I was aware that he was involved with people like them, but I don't know if I knew their particular names on that day. And you knew that these were people who were suspected of possibly being involved in organized crime. Is that correct? I knew he was dealing with people that were in organized crime. I don't know about these two people. Okay. Do you recall seeing Perry Berman at the police station that night? No, I don't. Now, do you recall ever saying anything to Perry Berman about the possibility that organized crime was involved in these killings? No. Did you hear the testimony of Perry Berman here in court? Yes, I was here. Objection irrelevant and also calls for hearsay. Overruled. Yes, I was here, says the witness. Okay, and did you hear some testimony from him referring to the fact that at some point you made reference to him about the possibility that organized crime was involved in these killings? Yes, yes. Are you telling us that that is not true, that you never said anything to Perry Berman about the possibility of organized crime being responsible for these killings? No, I'm not saying that. And can you, I did say it to people. Um, what? Then can you, I did say it to people to get off the subject when they were asking who did I think did it, who did it, probably to do with my dad's business. That is not a question, but it's listed under question, not answer. I think this was his continued answer was, no, I'm not saying that. I did say it to people to get off the subject when they were asking who did I think did it. Who did it? Probably to do with my dad's business. So did you say that? That's correct. Mr. Levin says, I would object. The court says, had you finished your answer? No, not really. The court says, you want to finish it? Erik says, and I would say that to people, but I'm just saying that to the police. I didn't think it mattered if I said it or didn't say it, but I did not say it. Okay, so who was it that you told that these killings could possibly be attributed to your father's business? I probably told Mark. Mark Heffernan? Yes. When did you tell him that? I don't specifically remember telling him, but that's probably what I would have said. That it had to do with it could only be one thing having to do with my dad's business. If it wasn't Lyle and I, and so to my relatives, I'm not sure that I said that. I don't think that they asked me. I don't know who else. Whoever asked me, I probably would have said it. Why do you say you probably would have said it? Because I didn't want to talk about it, and it was the easiest way to get off the subject. And is that because you and Lyle discussed at some point the fact that people would be likely to attribute violent gunshot or shotgun killings such as this to the mafia? We never discussed it. Are you saying that you and your brother, up until the time that of your arrest in March of 1990, you never discussed the possibility that people might attribute these killings to organized crime? It never crossed my mind until I started reading about it in the paper. I didn't know how a shotgun killing was related to the mafia, and I didn't. It never crossed my mind. Go ahead, he says. Did you become aware at any point that your brother was also telling people that these killings were possibly due to your father's business? I'm sure he said it in front of me, or I said it in front of Lyle. Are you saying that this is a I'm sorry, are you saying that this is a pure confidence? You never discussed that it might be a good idea if you both pointed the finger at your father's business as being responsible for the killings. No. I mean, I don't understand why it would be a good idea. I don't see why it would have mattered. It didn't matter to me at the time. I didn't think as long as uh, as long as long as they didn't think I did it, it didn't matter who did it. So he just wanted to get them off of him, change the subject so they weren't talking about him. You say you don't see why it would be a good idea. It's something that you did, wasn't it? You pointed the finger at your father's business. Is that correct? Right. I only say that in response to you saying it would be a good idea. It was simply what made the most sense, but I don't see how it would have benefited us, is what I'm saying. What you're saying is there was never any agreement or plan between you and your brother that you were both going to tell people that organized crime was probably responsible for the killings? That's right. So, did you have bodyguards in New York? I had a bodyguard one night. And that is the bodyguard that Mark Heffernan recalls you being with. Right. That's the night I slept in Mark's hotel room. Why did you have a bodyguard in New York that night? My brother was concerned that the mafia organized crime would believe we were talking to the police and we knew that people were following us, that there was cars following us, and it was tense. We didn't know what information my father had and what he knew that people didn't want to get out, and Lyle was concerned about it. He was concerned for my safety, and while I was in New York, he felt that it would be better if I had a bodyguard for one night. And I think he had for him 4 days, 5 days. So you didn't have bodyguards to create the appearance that you were frightened that the mafia would kill you. You just, as y- would kill you, just as they had your parents. Sorry. No, he says. You're saying that you had a bodyguard because you were concerned that the mafia might retaliate against you for pointing the finger at them? No, that's what I'm saying is that my brother was concerned. I remember seeing news reports that were directly linked to my father to organized crime in New York. And I remember discussing it with him, grandmother, that it was not so, to calm her down. I remember reading about it in the paper and that it was all over the place. And it was also discussed that we were talking to the police. And my brother was also concerned that my dad knew a lot of things that people would not want out and that we could be in danger. Yeah, you don't know what he knows and who he was associating with. And the concern lasted only about a week, but that's why we had them. So you thought that because, or your brother convinced you that because your father knew things about the mafia, then perhaps the mafia could be concerned about you talking to the police because you might reveal things about the mafia to them. Is that correct? Objection, vague, ambiguous, unintelligible, overruled. The witness says, right. It wasn't, I didn't, I mean, I didn't really, wasn't on my mind. I didn't really have the bodyguards, but Lyle was genuinely concerned about it, and I agreed to take the bodyguard while I was in New York that night. And did you say to your brother, well, if the mafia didn't kill our father, even though he had some information about the mafia, why would the mafia even suspect that we had the information or we're going to reveal that information? Right. But the problem was that there were people following us. There were cars following us. We were being followed and we didn't know why we were being followed. And Lyle believed that that was the reason and that we were talking to the police too openly and might reveal things. And that was his concern. We were paranoid. Now, did you at some point in time say something to Perry Berman about the mafia possibly being responsible for the killings? I don't remember doing so. He says I did, so I guess I did. Did you ever have a conversation with your Uncle Brian, Brian Anderson, about receiving a call from the mafia? No. Did you ever have any discussion with your Uncle Brian, Brian Anderson, about the mafia or any contact from the mafia? I don't. Telling him that I received a call from the mafia, I don't remember ever telling him such a thing. Did you have any questions with your Uncle Brian Anderson about the mafia or organized crime? I have no idea. Now, when you spoke to Sergeant Edmonds that night, August the 21st of 1989, did you tell Sergeant Edmonds about where you had parked your car that night? Yes, I believe I told him I had parked in front. Uh, I parked in front, if I understand what you're saying. Uh huh. Mr. Levin says, Your Honor, could we be specific on time when he parked his car? The court says, Was there more than one reference to parking the car? Mr. Levin says, I don't think the witness understood the question. The court says, Did you understand the question? The witness says, First I thought I did, and then I was beginning to think that I didn't. The court says, What did you understand about the question? The witness says, When I left the house that night, that I left through the front, not when I got back to the house, because my car was clearly in front of the house, and I left the house. Told him, I left the house. I told him I left from the front. What? No, no. Wait a minute. I told him I left from the back. I'm really confused at this point. If I could see the transcript, I'll know what I told him. Mr. Khan says, You told Detective Edmonds, excuse me, I need a sip of water. You told Detective Edmonds that you had left your home at about 8. Is that correct? If I could see it, I would remember. Let me ask you this. Are you saying you have no idea what you told Detective Edmonds about when you left home? No, I vaguely told him I left around that time, but I don't feel comfortable telling you that's exactly what I said off my memory of the conversation. Well, did you tell Detective Edmonds that you got lost going to the Civic Center that night? Right, I have a memory of that. Uh-huh. Was that true that you had gone to the Civic Center instead of going to the Santa Monica Civic Center? Excuse me? I think what I told him is I got lost in Santa Monica looking for the Civic Center. You told Detective Edmonds that you pulled in your front driveway when you arrived home that night. Is that correct? When that night? After, just before calling the police, just before making the 911 call. I don't remember if I told him I pulled in the driveway. I didn't pull in the driveway. So, well, let me show you page 2 of the transcript, directing your attention to line 16. The witness reads it and says, Oh, line 16, I'm sorry. I said both things. I said we pulled in the driveway and we pulled in the side. I didn't mean to convey we pulled in the driveway. You didn't mean to convey that? Why did you say that? You're talking about after those shootings when I got home, just before I called 911. My car was on the side of the road. I don't know why I said it. I don't know why I said I said a lot of things that probably are strange that night. I wasn't in the frame of mind of being interviewed, but I certainly wasn't trying to lie to him about that. Uh huh. I would object to all those uh-huhs if I was defense counsel. You told Detective Edmonds that you were even going to go out. I mean, it wasn't like a plan that where we'd always go out on Sundays. We just should have stayed in. We should have stayed in. Do you recall saying that? Vaguely. I recall saying it, yes. And can you tell us what you mean when you told Detective Edmonds we weren't even going to go out? I believe I was talking about the fact that we shouldn't have gone out. We shouldn't have asked my parents to go out that night. We can't remember, I can't remember specifically. Were you suggesting to Detective Edmonds that you had stayed home most of that day with your family? Probably. And was that truthful? I suggested that to him. No, it's not truthful. Why did you have to lie about that, Mr. Menendez? Why couldn't you have just told Detective Edmonds that you were out most of the day? In fact, you were out most of the day. Then he would ask me why I was out most of the day, and I'd have to explain I didn't want to be around my parents. When we got into it, it was easier to say I was home and it was a usual normal day. Well, why would you have to explain that you believed your parents were going to kill you just to tell him I happened to be out most of the day? What? Because that's the reason I was out most of the day. And so I just assumed that if I told him that I was out, I'd have to tell him why. So you just assumed that if you told Detective Edmonds the truth, that you had been out most of the day, that you would be then concerned into admitting, I'm sorry, you'd be cornered into admitting that you were out most of the day because your parents were going to kill you. I didn't think of it as cornered sense. I thought the reason I was out is because I was trying to stay away from my parents, and that's what the reason. So better not tell him I was out. Now, when you left the police station with your brother and Mark Heffernan, did you go directly to Mark Heffernan's home? No. Where did you go? We went back to the Beverly Hills house. What was your reason for going back there? I'm not entirely sure, but I believe it was to get my gear. And this was at 2 in the morning? Yes. And what happened at the Beverly Hills home? A police officer told us that they needed to search the car before they could give it to us, and so we couldn't get to the car. Mark then drove us back to his car. Uh-huh. And how long did you remain at Mark Heffernan's home? For a few hours, until we went back to the Beverly Hills house at 5 in the morning. Did you sleep during that time period? I don't believe I was able to sleep. Well, did you have a bedroom to sleep in by yourself? Right, he gave us a room to sleep in. And did you sleep together in the same room with your brother or in separate rooms? The same room. So you and your brother were alone in Mark Heffernan's home in the same bedroom? Yes. For how long? We got back to the house at 5. I don't know if I talked to Mark and his wife before we were alone in the room. I don't know. Well, how long would you say you and your brother were alone in the bedroom in Mark Heffernan's home? Half hour? Hour? I don't know. And did you both stay awake during that time period? I don't remember what we were doing in that time. I don't believe I was sleeping. You don't remember talking to Lyle Menendez during that time period? I don't even remember being in the room, to be candid. I just know that he gave us a room to sleep in. Might know that because that's what he testified to. I don't remember what was going on. So he's really only testifying to what he knows are the facts, but he doesn't really know for sure. Uh-huh. Again with that, uh-huh. It's driving me crazy. I mean, I would be objecting to that because that's like extra chatter from counsel that's not necessary. Sometime later, you and Lyle Menendez left the home to go back to the Beverly Hills home. Is that correct? Right. While you were in the bedroom with Lyle Menendez, did you tell your brother Lyle at that point, by the way, our parents were not armed? I don't remember what our conversations were. Like I said, I remember talking to him about that on the curb, the the curb, not the curve, the curb. I don't know whether we were talking about that before. I don't have a memory of that conversation. And so you went back to the Beverly Hills home at about what time? I believe it was still dark. 5 or 5:30. How did you get there? I don't remember that. I'm not sure if Mark drove us or we took a taxi or we drove. What was your reason for going back there at that time? To try to get in the car before the police were able to get in the car because if they searched, we would be arrested. But you didn't tell the police you wanted to get in the car. You told the police you wanted to get inside the house. Is that correct? 5:30? Sometime that morning, did you tell the police you wanted to get inside the house? I think later, at 8. That's what we said. At 5:30, we just told him, I believe the officer asked us what we wanted. And I think we just said to get in the car and he said we couldn't. We came back later and said we wanted to get into the house and that at least got us past the yellow tape. What time was the residence finally turned over to you? I think Detective Zoller testified around noon or 11. Well, why did you want to get inside the house at 8:30? I didn't. We just wanted to get into the car. How would getting into the house help you get into the car? That would get us to where the car was, past the yellow tape, and we were hoping just to be able to distract the police officer to talk to him some way, try to get into the car because as soon as they searched it, we'd be arrested. Well, the car was still on near the curb. Is that correct? Yes. It wasn't even inside the gate of the home, was it? No, it wasn't. And you thought that if they let you get inside the home, you would then slip out of the home and go over to the car and get inside the car. Well, no, there were police cars inside the yellow tape when we asked earlier. We weren't even allowed to go into the yellow tape area. So we got into the yellow tape area by asking if we could get inside the home. And as we were just talking with the police and just it was the only thing I could think to get to the car. It wasn't a great idea or great plan. It was the only thing that could get us to the car. What I'm asking you was that your plan at that point in time that you were going to get permission to go inside the home. And with that permission, you were going to somehow slip over and go to the car, and no one would notice you scrambling around in the back of the car. It wasn't a matter of slipping over. There were many police officers around. It was a matter of just casually talking, walking over to the car and going through it as if it was nothing since we had been inside the house. Just act like you belong there and nobody's going to question you. Just do it. Don't ask for permission. Just do it. At least that's what I live by. And what were you going to do inside the car? To see what was in it and to take what was in it. What did you believe was inside the car at that point? I believe there were probably some leftover cartons or wrappings or shells, anything that would link us. Why did you believe that there were leftover cartons or wrappings or shells? Because when we were going through the car at the gas station, we just thought we hadn't thought enough ahead. We were scrambling to create an alibi and just didn't think about the police are going to search my car and I was doing so many things, worried about so many things that I made mistakes and not getting everything out of the car was one of them. You were satisfied before you called 911 that night that you had removed the incriminating evidence from your car, weren't you? No, I knew when I called 911 that there could have been things in the car. I don't know whether I thought they were going to put the yellow tape around my car or not. I don't remember thinking about it. I'm telling you, I think they were in such shock that that's why all the things that they did to try to cover it up just don't make sense. Like they're not that well thought out, like he says, because they panicked. It wasn't planned, it just happened, and they were panicking in the aftermath of it. So your plan was to remove incriminating by like cartons, do you mean these big guns, these big gun boxes that they came in? No, the small shells, the shell boxes. So you were planning on removing incriminating evidence from the back of your car right under the nose of the police while there were police cars all over there? Luckily, there were a lot of clothes and there was extra bags, so we were just putting things in the bag. I remember finding a shell in front, not under, but in front of the front seat on the passenger side because I had searched the back seats and front seats and I remember finding a shell. We found carton boxes, wrappings, and we just put them in a bag with the other clothing. So you're saying that you were able to do that right under the nose of the police, is that correct? Yes, we were definitely able to do that. I'm sorry, that's funny. Again with the uh-huh. And did you feel why is my highlighter not on? Here we go. Did you feel that that was somewhat a chancy thing to do? I'm not sure that I thought it was a high likelihood I would not get arrested. I just assumed I would get arrested as we were trying to create an alibi. I was just trying to do it because it seemed the best thing to do. Not everything we did made a whole lot of sense. I was just trying the best I could to get an alibi, and to remove the stuff from the car was the only opportunity. And what time was it that you removed items from your car? I know it was around 8, I believe, around 8, 8:30. And you were sitting in your car when you saw Clara Wright? I think so. Where was your car parked at that time? I didn't move it. It was several hours later. It was still parked in the same spot. You had not moved your car from the time you removed the incriminating evidence from your car? Right. What did you do with the incriminating evidence once you removed it from the car? I don't know. I know that I threw it out. I just don't have a specific memory of throwing it out. Perhaps Lyle did, perhaps Lyle did, because I don't have the memory of specifically throwing in the trash. Do you remember transporting the incriminating evidence somewhere? I remember having the bag and knowing that the police officer was literally feet away. I don't remember what we did with it at that point. I think actually Mark Heffernan was there, so we put it in Mark Heffernan's car. Mark Heffernan drove us there at 8 and we put it in Mark Heffernan's car. That's right. You remained sitting in your car? No, I left and came back hours later. And how did you come back? I don't know if Mark drove me back or how I got back. Now, you were sitting in your car when you saw Clara Wright, is that correct? Yes. And you were sitting in the driver's seat? I don't know. I don't have a very good memory of sitting in the car. I know she said she saw me sitting in it, and that's why I'm more thinking that. I don't know where I was sitting. Was Lyle Menendez with you in the car when you saw Clara Wright? I don't think so. Is it true that the first thing you said to her was, Mrs. Wright, I'm so glad you're here. We need to speak to your husband? No. So if Clara Wright testified that way in this courtroom, you would say that that was incorrect. If she testified to that, then it would not be correct. I don't remember her saying that, and I don't remember her saying that was the first thing I said. Yeah, misstates testimony. Do you remember her saying, Eric said to me, Mrs. Wright, I'm so glad you're here. We need to speak to your husband. And either he was He said either that he was trying to get a hold of him or that he wanted to get a hold of him. Do you remember her testifying to that? Objection, Your Honor. It's not impeachment. It's irrelevant. Overruled. No, I don't. I don't remember it. Well, if she did testify to that, would that be wrong? Or objection, it's argumentative, says Mr. Levin. The court says overruled. The witness says, well, she can't, or she didn't come here and lie. So Erik says, well, she didn't come here and lie. So I don't know if it's incorrect or correct. My problem is that she didn't talk to the police until 4.5 years later. And so I never thought about the conversation again over 4.5 years. And so I just can't. Mr. Khan says, are you trying to suggest that she was mistaken? No, I'm trying to tell you why I'm having trouble remembering the conversation. Did you at any time that morning before you went to the Wright's house, say to Mrs. Wright that you needed to speak to her husband? I don't remember saying that. Hmm. Doesn't necessarily mean that he didn't, but he doesn't remember saying. Do you know any reason why Mrs. Wright would have a reason to call up her husband and tell her husband to come home that you and your brother wanted to speak to him? Well, obviously, if my parents had just died, she was going to bring her husband into it. Why is that obvious? Because in that household, Randy Wright was, at least when I saw them together, she was always quiet and he was always the loud one and saying what was going on. And he was the one that was going to be able to help us. Help you do what? Help us after my parents had died, whatever we needed. Help you do what? In whatever we needed, advice, anything that he was. Why would he be someone to help you? Because that's just who Randy was. He gave a lot of advice. He talked a lot and he was a very smart guy and that was just his personality. And it wasn't because you told her that you needed to speak to her husband. I don't remember saying it. I don't know why I would need to speak with him. I may have wanted to. I don't know why other than those reasons. Now, do you recall the testimony of Mrs. Wright that before her husband arrived home, that the three of you sat on the couch for about 20 or 25 minutes? That is, Erik Menendez, Lyle Menendez, and herself? I don't remember that specifically in her testimony. No, I don't either. Do you remember her saying that it was during that time period that Erik Menendez brought up a conversation about a computer and asked if anyone in the family knew how to work a computer? I believe she said just the opposite later in her testimony that she was not sure and she now believed it was later. Do you recall saying to her something about you suspected that there was a will in the computer? Right. That was brought up when Randy was there, and that's when the conversation with her took place, and I believe that's when she testified to. Now, do you recall the testimony of Randy Bright that he had not mentioned anything prior to Lyle bringing up something about probate, that he had not mentioned anything about your father's will or anything to do with the will or the money? Objection, it's irrelevant. It's also compound. The court says at this stage, unless there's a foundation, it's irrelevant. Mr. Khan says, was there any discussion about your father's will or about your father's money prior to that time that there was a question about Randy Wright probating the will? Randy Wright, from what I remember, testified that he brought up the conversation about the will. In fact, it's not what I remember, it's what he said. And that, at this point, the discussion about the will, what would happen, where was the will, the fact that he had probated wills before, that he could help us with this, and that's when it was all discussed. I don't remember Lyle being there, but I find it very difficult to believe that Lyle would have brought up and said the word probate before my parents ever died. It's just not something I had ever heard before. Do you recall Randy Wright saying that he had not mentioned anything about your father's will or about anything having to do with the will or money until Lyle Menendez mentioned probate. I think that's wrong. Mr. Levin says, objection, Your Honor, misstates the testimony of Randy Wright. Rephrase the question, please, says the court. Mr. Khan says, yes. Did you at any time mention anything about your father's will or anything having to do with the will or money before the issue of probate came up? I don't know when the issue of probate came up. I know when probate, I'm assuming, went along with will because that's what Randy testified to. But I know that Randy brought it out, and that's when it was all discussed. No. Isn't it true that the first one to bring up the issue of the will and probate was your brother and not Randy Wright? That's just the opposite of what Randy Wright testified to. I love when a witness can fight back and not take a prosecutor's shit. And Erik's holding his own pretty well here, I gotta say. I think he's doing better on cross probably this time around than last time. Probably because he knew more what to expect. All right. So now, did you say during your conversation with Randy Wright that your father might have changed his will? No. What I said to him is that there might be a new will because my father said he was going to take us out of the will. And so there might be a new will. And he was asking where these wills could be. And that's when we discussed the safe and the computer and so on. Did you discuss with him that there might be a new will on the computer? I may have. It was my mom's computer. I didn't really believe there would be a new will in the computer. If it was in the computer, then it was in some attorney's hands. So some other attorney would have had it if it existed. Was there a concern on your part that there might be a new will in this computer? What do you mean by concern? That I believe there was a possibility? The possibility existed. Did you hear the testimony of Clara Wright that you were very concerned about a will in a computer? I remember her saying that. I remember her saying something along the lines of, I wanted to go through the computer tooth and nail, I think is what she said. And I did. I did want to. There's no question. Objection. He's not finished, says Mr. Levin. Let him finish, says the court. The witness says, there was no question, but that had to do with my mom, letters of hers, secrets, things about the family that she would type in as a diary. So she used the family computer for. I wonder what they found on there. I wonder what her diary said. That would be interesting if that ever came into discovery. She used the family computer, but it was hers really, and it was kept in the parents' bedroom. She used it as like her diary. She would write stuff in there. I wonder if there's stuff in there that proved the abuse, but maybe was held from the defense at some point in time. I don't know. Maybe, possibly. Mr. Khan says, when you were in the Wright's home, you did not speak about letters or diaries. You spoke about the possibility of a will being on a computer. Is that correct? Right. But I thought you were asking me about Clara Wright, and I don't think she connected the will and the computer to me wanting to go through it tooth and nail. Do you recall the testimony of Clara Wright that you were very concerned about a will in a computer? I don't know. If you would just read me the testimony, I'd be able to tell you what exactly she said now. It was many months ago, and I can't really go over the exact words that she used. I haven't read her testimony. Well, do you recall her being asked, did you talk to did he talk to you about why he wanted someone who could do something with the computer or work with the computer? And she responded, yes, he wanted to get into the different compartments, files, or I don't know the computer terms he used of the computer because he suspected that maybe there's a will in the computer. I'm laughing because this is 1996 and people weren't as tech savvy back then. She testified to that here. She did. Do you recall that? If she said it, then she said it. Is that because you had is that because you had that conversation with her in which you indicated to her that you wanted to get into the computer because you suspected that there was a will in the computer? No, I suspected that it's more. The computer was brought up when the will was brought up, and so in her mind, she's connecting the two, but I don't believe that I said it. I wouldn't have said it. It just doesn't make sense to me. Isn't it a fact, Mr. Menendez, that on the morning of August the 21st, 1989, you were very much concerned about the will and the money in the estate? The will and the money in the estate had almost no concern in my mind. I wasn't even sure that I wanted the money if I was in the will. And your reason for visiting Randy Wright for the first time in his home was just because he was a nice man, is that correct? No, that's not what I said. Now, when your parents, yeah, he's like totally putting words in his mouth or twisting his words or whatever. When your family came to California following the killing of your parents, did you know at the time that Carlos Peralt was probably the executor of the will? I didn't know what an executor was. Do you think that Carlos Peralt was going to play any role in the disbursement of funds from the estate? He was one of the primary uncles and aunts in the house. He was my dad's brother-in-law, so I assumed that he was going to. My Aunt Marta, my Aunt Terry, my Aunt Joan, my grandmother. Did you think that Brian Anderson was also going to play a role in that? Probably. And did you ever tell Carlos Baralt that you believe that you were not in the will? I don't think I said either way to him. I'm sorry? I don't think I said either way to him. Uh huh. Somebody count the uh-huhs because there's so many of them. But you knew that there was a lot of talk about getting into the will or finding the will and finding out how many wills there were. Is that correct? Right. They had found a will on Wednesday, I think. And then I know I told Carlos there would be a new will, and then there was a lot of effort to try to find the new will, and then that went on for probably about a month. Did you tell Carlos Peralt at any time that you didn't believe that you were in the will? No. Did you tell Brian Anderson at any time before the will was found, that you didn't believe that you were in the will? No. And in fact, is it true, Mr. Menendez, that while you were looking for the will with your Uncle Brian, your brother had a conversation with him about inheriting under the will? I don't remember it. I'm sure I did. I remember specifically the conversation with my Aunt Marta and telling her that I was not in the will. Are you sure that you had a conversation with your Uncle Brian about that? Why are you sure? What? Because I'm not sure that I did. You just told us a moment ago. I'm sure I did. I meant in terms of I probably did. A lot of the relatives were discussing it, but they weren't discussing the details of what was in the will until my Aunt Marta brought it up to my brother and I. I'm not asking you about your Aunt Marta, Mr. Menendez. I'm asking you about your Uncle Brian Anderson. Do you know the difference between the two? Yes, sir. Now, in regard to Brian Anderson, did you ever tell him at any time that you believed that you were not in the will? No. And in fact, you even asked him at one point for his assistance in what you were going to do with your money under the will, didn't you? That was about 2 months later, maybe 3 months later. Are you telling us that during the time period when you were looking for the first will, there was no talk with your Uncle Brian about how he would assist you with your money that you would receive under the will? I had a conversation with my Uncle Brian many months later when I knew that once the will issue was settled, where he advised that I go into real estate because that's what he was in. Certainly, we did not discuss it in that week, the first week, what in detail we should do. I don't think that he would have brought it up. I don't think I would have brought it up. I don't think that's something anyone was thinking about at that time. I'm not asking you about in detail. Let me repeat the question. I'm saying that week before the first will was found, did you have a discussion with your Uncle Brian Anderson in which you indicated to him that you would like to have his assistance concerning the money that you would receive under that will? I don't remember. Now, when the will was finally found, you went with your brother Lyle Menendez and Carlos Baralt to take a look at the will. Is that correct? No, I remember hearing about it when I got back to the Beverly Hills house that everyone was upstairs and I went upstairs and they said they had found an old will. Where were you when you saw that will? Either in the hallway or in the entrance of my parents' bedroom. Who was nearby? My uncle Carlos. I remember specifically he was holding it. And you learned at that time that you were included in the will. Is that correct? Well, he said it was a 10-year-old will, a many-year-old will, and that there was probably a new one. And I said, "You're right, it's an old will." And at that point, there was a search for a new will. Uh huh. Uh huh. And also, you knew that you were going to collect the money under the Sun Life policy, didn't you? Objection, vague as to time. The court says establish a foundation. Mr. Khan says yes. Prior to the time that you collected under the Sun Life insurance policy, did you know that you were going to collect under the Sun Life insurance policy? Yes. How did you know that? My aunt Marta told us that in the conversation when she detailed what she thought was going to be in the estate. When did you have this conversation with your aunt Marta? I believe it was Wednesday night. Maybe it was Thursday. I'm not sure. Was that after you visited with Randy Wright? Yes. Well, at any time, isn't it true that at any time you visited with Randy Wright, you knew you were going to collect under the Sun Life insurance policy? I didn't know the Sun Life insurance policy existed. Well, did you hear the testimony of Randy Wright concerning the fact that during that visit at his home, there was a conversation in which it was expressed that there was a policy in effect for $300,000? Right, I definitely remember him saying that. And did you, in fact, have a conversation with Randy Wright in his home about the fact that there was a policy in effect for 300,000? I don't believe we did. Would you say that Mr. Wright is mistaken about that conversation? Well, I believe I know where they got that from, and I'm quite sure that he's mistaken. He's mistaken. I'm quite sure he's mistaken, yes. You said you rely upon him for his testimony. Is that what you said? Yes. Now, you went shopping for Rolex watches and money clips within approximately 4 days of shooting your father to death. We didn't go shopping for Rolex watches or money clips. Well, you just ended up buying Rolex watches and money clips within 4 days of the shooting your father to death. Right. How did you just end up doing this? We were there when I was buying a jacket to wear to the memorial service, and during the time it was getting tailored, we were walking through the mall. It was an outdoor mall, and I walked into this jewelry store. And you just said, let's spend thousands of dollars on gold jewelry? I wasn't concerned about thousands of dollars, no. You weren't concerned about thousands of dollars, were you? I'm sorry? You weren't concerned about thousands of dollars, were you? No, I wasn't concerned about it because he's never had to worry about money in his life. So, what's a few $1,000s to a millionaire? I mean, okay. And so you were spending that kind of money, weren't you? Mr. Levin says, objection, it's vague. Overruled. I know we bought the watches, yes. How much did the jewelry cost? I'm not sure if it was 10,000 or 15,000, something along those lines. How many gold money clips did you buy? I don't remember. I just remember having nothing to carry money around that I needed to carry. Well, what have you gotten by within What have you gotten by with in the past? Well, in the past, I ate at home. Everything I used was at home. I don't believe I used gas. I believe I used a gas credit card and had everything that I bought was at home. And now you knew you would be living a new life and you needed something that would be appropriate to the lifestyle you would be living. What? No, now I was paying for a lot of things and it was in the store, so I bought it. They're young too, 18 and 21. Of course, they're going to gravitate towards like the fancy watches and the designer things. They've grown up with designer things. So why wouldn't they? So how many gold money clips were purchased that day? I don't know. Was it two, one for each of you? I don't know if it was two, three, four. I don't know. Do you think it might have been more than two? Whatever is in the receipt is how many we bought. So why did you need gold money clips? That's what they were selling in the store. It didn't make any difference to me whether it was gold or silver or copper. You bought it because that's what they were selling? Yes, that's exactly right. The question is, why did you have to buy it? I don't know. I didn't have to buy it. I didn't think about a money clip before I got it. I just knew that I was carrying around cash and I was there, and so I bought it. It was easier to carry around. And how much cash were you carrying around these days? I don't remember. There were a lot of bills. Everything was unorganized very early on, and I don't remember. How was the jewelry paid for? I believe it was on a credit card. It was on a credit card. Was that in your brother's name or in your father's name? It was the gold MasterCard or American Express that my father had given my brother. Uh-huh. And when he gave that card to your brother, did you understand that your brother then had permission at that time to go out and purchase gold Rolex watches? There was a $250,000 limit that Lyle could spend on the card. So I think he had a good amount of credit left even after he bought the Rolex watches. So are you saying that you felt that Lyle Menendez had permission to spend 250,000 on that card? That's what my dad made the limit for my brother to be able to spend on the card if he needed to. You're telling us that Lyle Menendez, in your mind, had it was okay with your father to spend 250,000 on that card. Is that correct? No, that's not what I'm saying. What are you saying? I'm saying if he needed to, he could spend up to 250,000. That's what my dad put the limit for my brother, and that I didn't believe there was a limit set. That I didn't believe there was a limit set. I don't know. What are you saying? Okay. Did you feel that when did your brother receive that credit card from your father? My brother had credit cards from my parents from the time he was like 17 or 18. Do you feel that from that time he was 17 or 18, he could go about and buy a $70,000 Porsche? Objection calls for speculation. Overruled. The witness says no. Mr. Khan says the fact that he had a card with a specific limit on it doesn't mean that your brother had the permission of your father to go run up a $250,000 bill, did it, Mr. Menendez? Objection, argumentative, and calls for speculation. The court says, as phrased, it's argumentative. Rephrase the question. How much did you feel your brother could run up on the credit card with your father's permission? Well, I know that he ran it up 10, 15, 30, 40,000 on the card before they died buying things. So I know that he had permission to spend up to $250,000. I'm not making up the number. The number is there and it's what my dad put on the number. And he had permission to spend up to that amount. Obviously, if he spent 250,000, my dad was not going to be happy. He clearly had to account for what he bought. But you're asking me what he had permission to spend up to? He had permission to spend up to what dad allowed him to spend up to. You're saying your brother ran up a $40,000 bill on that card? I'm saying that he spent up to $40,000 before they died. And the only way he could have done that was on the credit card. On what? What did he purchase for up to $40,000? He purchased clothing. I know that my Aunt Terry had called, and I remember my dad knowing that Lyle had spent, I don't remember how much money before he went out to New Jersey and on girlfriends and gifts. And when he got out there, he learned that it was for clothing and things for himself. And so that calmed him down. And that Lyle made those expenditures was not out of the ordinary. So he was buying not only things for himself, but he was also buying gifts for his girlfriends and things and probably like friends just, showing off and like, I got it here. So interesting, huh? That he could spend up to $250,000, or at least that was his limit. And those expenditures upset your father, didn't they? My father was upset when he thought Lyle was spending money frivolously on girlfriends or junky clothing. When he found out that Lyle would buy things like that or a lot of Princeton outfits and some very expensive things like that, he found out that they were conservative or more classy, that he was pleased about that. So he was pleased that he bought conservative, classy clothes to go with his Princeton, uh, his Princeton, I totally lost the word, what I was thinking, to go with that part of his life, the Princeton people. And that was one of the reasons why there was tension in the home, was because your brother's spending. Is that correct? Spending on his girlfriends. My dad believed that my brother's girlfriends, Christy and Jamie, were gold diggers and sluts. Well, doesn't mince words there. And he called them, and as he called them, gold diggers and sluts and low class. He didn't want my brother hanging around them. The fact that he was buying plane tickets to buy Christy, to fly Christy, to fly home or to fly Christy out to New Jersey infuriated my father, and my father had a conversation with my brother about that, and that ended because a lot of the spending was like flying out one another. In fact, he had to end the relationship with Christy at that point. Mr. Menendez, why was your father such a powerful man, so ineffective in controlling your brother and his spending? Objection calls for speculation. Rephrase the question. Yes. Can you tell us, Mr. Menendez, why your father was ineffective in controlling your brother's spending? Objection calls for speculation, maybe his belief. The court says, are you asking for his state of mind as to the impression of his father? Yes, Your Honor. Court says, okay, with that clarification, what's your answer? I don't believe that he was ineffective. My father was usually effective in everything he did. He had a conversation with my brother in May when my brother was staying at my Aunt Terry's house, and they talked about spending. Lyle apparently purchased something on my mom's visa that my mom was not happy about. So it was understood that my brother would not spend any more money on my mom's visa. And it was understood that Lyle would spend money on himself versus spending money on his girlfriend and these women, as my dad called them, and buying gifts and spending money on them. So there were certain aspects of Lyle's spending that would make your father very upset. Is that correct? Right. Objection calls for speculation. Overruled. The answer will stand. Well, that led to frustration and tension in the household. Is that correct? It certainly led to frustration until they had this conversation where my dad made it clear that Lyle was to spend money on himself instead of buying expensive presents for his girlfriend. That was made clear. And it at that point, I believe he was ordered to break up with Christy, and he did. Was it your understanding that one of the reasons your father was going to cut your brother out of the will was because of his spending habits? No. I mean, maybe. I mean, my dad felt Lyle was spending money on girlfriends, perhaps, but my dad was, you're right, it could be. It would be a good reason. And when he stopped doing it, he put him back in the will. It's just the way things ran. You said that with yourself. It was the Calabasas burglaries was perhaps the straw that broke the camel's back, as far as you possibly being removed from the will. Objection. Overruled. What I said is the Calabasas burglary had something to do with it. I know my dad was extremely upset with me in the fall and late summer over my ranking in tennis, and it wasn't a shock to me that I was taken out of the will, at least temporarily. Maybe it was just something he constantly threatened them with to get them in line or something. I don't know. It's not like they were really threatened because they had everything they needed financially. All of their financial needs were taken care of. All of their wants were taken care of. Like physical, desires were taken care of. But when it came to actually like being good parents, they sucked at that. Uh, was it also your understanding that the Calabasas burglary had something to do with why your brother Lyle was going to be taken out of the will in addition to his spending habits? I don't know. Isn't it true, Mr. Menendez, what your father had was two sons that were pretty much out of hand? Objection, calls for speculation. Overruled. I was not out of hand. I couldn't be out of hand with my father. If I was out of hand, there were serious consequences. That would not happen in my household. Where were the serious consequences to the two burglaries you were involved in, Mr. Menendez? To the burglaries? There were no serious consequences to the burglaries. If there wasn't serious consequences to the two residential burglaries, Mr. Menendez, for what would there be serious consequences? Well, you have to understand my dad's values. The burglaries he felt were screwed up by putting a lot of the stuff back because we felt guilty for that. And he thought that was stupid, idiotic, and crazy. And he was upset. He was upset that we had done them in the first place, also. But his concern was tennis, and that May, the spring of 1989, when I wasn't telling him what I was doing at every hour in my tennis practice, he was about to disown me. The burglaries he wasn't going to disown me for, not obeying him in tennis, he would. His values were very different than those that you're suggesting. Mr. Menendez, your father was a man who was very much concerned with his image, is that correct? Yes. And now he had two sons who were involved in residential burglaries. Is that correct? What do you mean by that? Are you saying that your father was not upset about the burglaries, even though that this is something that could potentially affect his image? Oh, no, he was upset and he brought that up. That's the reason why we moved from Calabasas to Beverly Hills, was to get away from the scandal of the burglary. The burglaries was a stupid thing and they were not going to happen again. But my father was much more concerned about tennis and me not doing enough in tennis than he was about the burglaries. Your father was a man who said you believe was going back to Florida and potentially would run for the United States Senate. Is that right? Yes. And now he had to move out of the Calabasas residence over to the Beverly Hills residence because of a scandal involving residential burglaries committed by his sons. Is that correct? Right? And you feel that that was not sufficient for him to punish you for some serious consequences for objection, vague, ambiguous. The court says you're asking his current state of mind or his state of mind in August of 89. His current state of mind. It's irrelevant, says Mr. Levin. The court says overruled. The witness says, what I'm saying is that I could just go on what my father said and did. The consequences for not telling him about tennis were much more extreme, and that's just how I felt it would be. At the time that he said I was out of the will, I thought most probably it was because I was ranked seventh, and he was angry about that and had been angry for a while. The burglaries were, in his mind, a fly by night thing. He was upset and angry over the way it was handled, over what we had done. And he didn't want to stay in Calabasas because of the potential scandal. And that's just the way it was. He was more upset that they got caught than actually doing it. Mr. Khan says, so the reason why he did not impose serious consequences upon you despite your involvement in these residential burglaries was what? In my household, I didn't know what was going to get punished for and what I was not going to get punished for. I never knew what I was going to get punished for. There were things I should have gotten punished for as a little kid that I didn't get punished for, and things I didn't have anything to do with that got severely punished for. You just didn't know. It depends on what was happening in his life, what his mood was in, and what he was hearing from my mom. I'll say that again. And what he was hearing from my mom. What was mom whispering in Jose's ears when he would come home saying, well, Lyle did this and Eric did that? My question is, what was your understanding as to why your father did not impose serious consequences on you, even though you and your brother had been involved in a residential burglary, which caused a scandal and required him to move out of the neighborhood? Objection with respect to required. The court says, all right, why don't you clarify that? Yes, my question to you is, what was your understanding as to why you did not receive serious consequences for your behavior in the residential burglaries, even though you and your brother had been involved in an incident which had caused your father to move out of the neighborhood? I don't know what serious consequences you think he should have done. I don't know what happens in normal families. I just knew what happened in my household, and my father did what he did. I thought that he was more embarrassed by the burglaries. It's just something he didn't severely punish us for. He was more concerned with other things. Mr. Menendez, isn't it true that your father cried about the Calabasas incident? My father would never cry in front of me. I know that my brother said that later, and I believe that happened at one point, but I never saw such things. What happened at one point? I'm just going off of what I heard on the 1211 tape. You heard on the 1211 tape that when Lyle Menendez said to Dr. Oziel that your father cried after that Calabasas incident. Isn't that correct? Objection, irrelevant, and hearsay. The court says you're asking at the time of that conversation on December the 11th, 1989? Yes. Did he hear his brother say that? Yes. Overruled. I think that Lyle said it. I think what Lyle said is that my father could not express love for him, could not express emotion in front of Lyle. And the fact that he was shocking, that it was the fact that he did was shocking. And it had never happened before. And that I think he brought up because he was talking about how difficult it was to express emotion and his love for my father and my father's something. I don't know. Why does that get caught off? Mr. Khan says, my question to you is, did you learn in that December 11th tape during that time that your father had cried over the Calabasas incident? Yes. And isn't that inconsistent with what you're telling us here that your father apparently did not regard the Calabasas incident as a big deal? How is that inconsistent? Objection, Your Honor. That's not what he testified. Court says rephrase the question. Mr. Khan says, is it your testimony here today that the Calabasas incident was not something that, in your father's view, warranted serious consequences? Objection calls for speculation. Overruled, says the court. What, in my father's view, warranted serious consequences, I don't know. It was very ambiguous what he regarded, he felt should have serious consequences. Certainly, tennis, I knew there would be serious consequences. But in other serious things in life, I had never done a burglary before and I never did one after. And he didn't believe I was going to. It was a serious thing. Clearly, it was a serious thing. There was no doubt that it was a serious thing. My father wasn't happy, not pleased. He didn't view it as a little thing, but it was not something that in his mind, for whatever reason he had, was going to be as serious as the punishment for tennis. Court says, let's take our recess and we'll resume 20 minutes later. Court says, okay, let's get the jury out. So now they come back. We're back from our break. The court says the jury is back in court. You may continue your cross. Mr. Khan says, thank you. Mr. Menendez, you didn't have a lot of money to spend on showy things before you killed your parents, did you? I never really spent much money. And my question is, did you have much money to spend on showy things? No, I never asked my parents for a credit card. I just wasn't the type of person to spend a lot of money. Well, Lyle Menendez didn't have your father's permission to spend money on showy things such as Rolex watches, did he? I know that objection calls for speculation. How do you know? Maybe he would have approved because it was a Rolex, just buy a good one, son. Don't embarrass me with some cheap ass Rolex. Get a good one. That's probably what he would say. Um, yeah. So the question, let's go back. What was the question? Well, Lyle didn't have permission, your father's permission, to spend money on showy things such as a Rolex watch, did he? Eric says, I know that he bought Movado watches, an expensive watch, that my dad had expensive watches. I know that he bought two watches. My question, says Mr. Khan, and then the witness continues, he had the money to spend it. He didn't. My question to you is, was it your understanding that your brother Lyle had your father's permission to spend money on showy things such as Rolex watches? He definitely bought things for himself on my father's credit card. I don't know what he had permission to do or not to do. I don't think it was a matter of permission or a matter of buying it and telling my father about it. Well, did you have an understanding as to whether or not your brother Lyle would wanted to purchase a Rolex watch prior to the time that he purchased it 4 days after killing your parents? In between the time my parents died and the time he bought the Rolex watches, I didn't discuss it. I'm asking you if it was your understanding that Lyle Menendez had wanted a Rolex watch prior to the time that he purchased one 4 days after killing your parents. I know that. Are you limiting it up to the time my parents died, or can I go before that? I'm talking about before that. Before my parents died? Yes. I know that a year and a half, 2 years before my dad had a Rolex watch, and my brother wanted one like my father's. And I know he wanted one at that point, but that was a few years ago. I know he wanted one then. After that, I never discussed it with him. Well, was it your opinion that your brother Lyle had a lifelong ambition to get a Rolex? What kind of dumb question is that? His dad had one. Why wouldn't he want one like his dad? His dad wore flashy, showy things like Rolex watches and stuff like that. Why wouldn't the kids want to, take after their parents? They would, you're going to take after their habits, whether you mean to or not. You're going to see your parent buying the flashy, showy things, and you're going to want the flashy, showy things too, because that's just how it is. Well, was it your opinion that your brother Lyle had a lifelong ambition to get a Rolex? A lifelong ambition to get a Rolex? I don't know if that's a flippant way of saying it or not. I know that when my father had one, he wanted one. I don't know how to answer that question. Well, let me ask you this. Did you previously tell Detective Zoller on September the 17th of 1989 that your brother had a lifelong ambition to get a Rolex? I don't remember saying that. If you can show me. Yes. The court says, why don't you tell us what page? Mr. Khan says, yes, this is page 38 of the transcript. Mr. Levin says, 38? Yes. I only have 33 pages. What page, says the court? Mr. Khan says, it's 38 of, it might be a different transcript than the one that's in front of the court. The court says it has 33 pages. Mr. Khan says, right, I think it's a different one. The court says, this is not Exhibit 53. No, it's not that exhibit, says Mr. Khan. The court says, well, do you know what page this on? In 53, Exhibit 53. Mr. Khan says, I think this is different material. The court says, are you talking about September 17th? Mr. Khan says, but I am talking about in addition to. Levin says, Your Honor, we would request to approach. The court says, let's see if we can clarify things with a discussion with counsel. Mr. Khan says, okay. Following proceedings were held at the bench. So this is a sidebar, basically. Court says, outside the jury's presence, what are you referring to? Mr. Khan says, This is from the original unredacted transcript, which is now relevant. The court says, well, what is the difference between the two? Mr. Khan says the main thing that came out from the original transcript was simply this one reference to Lyle's lifelong ambition to get a Rolex. Court says, okay, so is there an objection to the use of this? Well, I don't have this memorized, Mr. Levin says. I would like to know what it is. The court says, why don't you show it to him? Mr. Gessler says, although it might now be relevant, it wasn't relevant. It was before it was redacted, and I think we should have some notice when something is going to be read. The court says, I think if you're going to refer to an exhibit that we don't all have available, if you could give us advance notice that you intend to use it. Ms. Abramson says, I could go get a copy of it out of the cabinet if I had known he was going to use it. Mr. Levin says, are you going to refer to it again? Mr. Khan says, no, just this one area, but there is another reference on the next page. Court says, why don't you look at both of them? Mr. Gessler says, I think this is too ambiguous on page 39. If you're going to ask him about, quote, my dad didn't like that, it was showy, quote, end quote, I would object to that as being too ambiguous to be impeaching. Mr. Khan says, I think that the court says, we don't know what his answer is yet. So Mr. Gessler says, he can't answer something that's that ambiguous as a question, Your Honor. The court says he might know what his father's opinion was of the watch. I don't know. Mr. Gessler says, but this doesn't necessarily refer to the watch. The court says, I am saying at this point the foundation has to be established first before we even get to that, and then before a question is asked on that next page regarding what is showy. I'll look at it if there is a lack of foundation. Ms. Abramson says, I don't need to see it. I remember it. Mr. Gessler says, I don't think it's concrete enough that it refers to a watch. It's talking about clothes, then talks about showy, and I don't think it's tied down to enough to be impeaching. The court says, well, depending on what the witness's answer is, the witness can be asked, did he describe certain purchases as showy in this conversation with Zoller? And he can say what it was. Gessler says, all right, as long as it's not referred to in the question as a Rolex, which we don't know that it meant. Which we don't know what that it meant. Okay, whatever. The court says, let's first, some of the way that we talk in normal life isn't the way that you necessarily arrange your words if you're writing a paper or something. It's not always grammatically correct. So sometimes we just say things in a weird way and it comes off strange. So, anyways, Mr. Gessler says, all right, as long as it's not referred to as the Rolex, we don't know what he meant. The court says, let's first see what the witness's answer is. Mr. Levin says, if that's the only reference in that transcript, then I don't need to get ours. Mr. Khan says, no, it's just these two things. Mr. Gessler says, David, did you hear the restriction on the question? Basically, what he meant by showy without referring to a Rolex at that point. Mr. Khan says, okay. Mr. Gessler says, okay. The court says, thank you. The following proceedings were held now in open court. So we're back to examination. All right, the court says, let's proceed. Mr. Khan says, let me show you the passage that you requested to see, Mr. Menendez. Thank you, says Erik. And I ask if this refreshes your recollection. Yes. So my question is, do you remember telling Detective Zoller on September 17th of 1989 when he interviewed you that it was Lyle's lifelong ambition to get a Rolex? Yeah, I think I was being flippant, or he asked about the Rolex watches and it was my way of expressing that he wanted one. Was it true that your brother Lyle had a lifelong ambition to get a Rolex? No, that's not true. Well, then, can you tell us why you told Detective Zoller when he asked you about the purchase of the watches prior to the memorial service, you said it was Lyle's lifelong ambition to get a Rolex? I think there was a lot of pausing before that, just trying to find words to express that we bought watches. I didn't think it was that big of a deal, and it was his lifelong ambition. I don't know why I said it. I can't remember the question, but I did say it. You can't answer that? I don't know why I would have said something like that. I don't know what Lyle's lifelong ambition was, and I certainly didn't discuss it with him many years before, at least a year and a half, 2 years. So, I mean, I don't know. And at some point in the conversation with Detective Zoller, do you remember using the word showy? Right. In reference to wearing the watch, I think I said that he was asking about wearing it at the memorial service, and I said that Dad wouldn't do that. He didn't like to wear a Rolex out in a showy fashion. Why were you telling Detective Zoller that your father wouldn't wear a Rolex because he felt it was showy? I was meaning to express out at a function such as that. I don't know why. I don't know why I said those things or what was going through my head. I don't know. Did your father regard Rolexes as showy? At certain times, wearing the Rolex watches he felt was showy. My father was a conservative, secretive, private man, and he didn't wear long chains, showy things like that. He just did not do that. And is it true, Mr. Menendez, that Lyle Menendez did not have your father's permission to go out and purchase a ten or $15,000 Rolex watch, and that is the reason why he had a lifelong ambition to get one? Compound question. What? I don't believe that Lyle had a lifelong ambition to get a Rolex watch. He didn't. I also don't believe he had permission to get one. You agree that he did not have permission to go out and purchase a ten or $15,000 Rolex, is that right? Objection calls for speculation. I never meant to indicate that he did. I just said he spent a lot of money on different things. What he had permission to buy exactly, or what arrangements he had with my father, is things that he discussed and that I became aware of. Now, let me go back just a moment to the day that you went to the home of Randy Wright. At some point during your visit with Mr. Wright, did you bring a safe over to the home of Mr. Wright? Yes. How did you get that safe over to the home? Apparently, my brother and I carried the safe to his house. And what size was this? It was a safe in my father's closet. I remember seeing it in a video that you showed, maybe a 150-pound safe. Was there a discussion with Mr. Wright about bringing the safe over before it was brought over? Yes, he said that the will might be in the safe. We had really discounted the real possibility of a will being in the computer of being of use, and so we focused on the safe, and he wondered if there was a changed will or a new will or any type of will, and that's the best likelihood where it would be. Mr. Wright wanted it in his house, and so he felt that we should bring the safe over and give it to him, which is what we did. So Lyle was present during the conversation. Is that correct? Apparently. You testified previously you don't know or you didn't recall that Lyle was there. Is that correct? I don't recall bringing the safe over. I thought we brought the safe over a day later, to be candid. Mr. Wright testified that we did. I don't recall it. It may sound strange, but I just do not remember that. But since Mr. Wright testified that we did, I know got there somehow. They got it there somehow. How did you know that you had a safe in your home? Good question. I don't know. May have been Lyle that brought it up. I have no idea. But it was either you or your brother during that conversation that brought up the fact that there was a safe at the home. Is that correct? Right. And the two of you left the residence of Mr. Wright to go home and get the safe. Is that correct? Right. And what day do you believe that happened? I had never thought about it for 4 or 5 years, so I just went out of my memory. I never thought about the conversation with Brandy Wright. I never thought it would ever be of importance, so I never focused on it, and I never focused on it and tried to remember it. And when I tried, I thought that we had brought it over when we went to open it. Apparently, we brought it over that night, so I believe we brought it over that night. So did you bring it over on Monday night? Is that correct? No, I can't tell you independently that I remember that, but I can tell you that Mr. Wright remembers that, and I am not saying that that's not true. Well, how did you transport the safe from your home to the right home? I thought we brought it over in the limousine with my Uncle Carlos and Uncle Brian. If we didn't bring it in the limo and we brought it Monday night, then it was one of the cars, one of the family cars. Lyle's Alfa Romero was not working, and so it might have been my Escort or my dad's Mercedes. I don't know. How many family cars were there besides the Escort, the Mercedes, and the Alfa Romero, or was that it? My mother had a convertible Mercedes, and my father had a larger, full-sized Mercedes. And you don't recall what car you used to transport it over there, is that correct? Yes. Do you remember Mr. Wright expressing some concern that the police may not allow you to transport the safe at that point in time? I don't remember it either way. Do you remember Lyle Menendez responding to that he could get the safe? Responding to that he could get the safe. Well, on Monday night, the police were no longer there, so we would have been able to get the safe. But the question is, do you remember Lyle Menendez indicating to Randy Wright that he could get the safe? No. And you didn't have to describe the safe to Lyle before Lyle made any comments about the safe, did you? No. Now, after you killed your parents, your lifestyle changed somewhat, is that correct? My entire life and everything in it changed. And you had more money to spend, is that correct? That's true. Did you purchase a Jeep? I did. How much did you pay for the Jeep? 20,000, 21,000. To make purchases, did you use a California driver's license? I couldn't purchase anything with my California driver's license, but I used a credit card that my Aunt Marta gave me. I used checks that she gave me, and I know that I did go to the DMV to get a driver's license for ID verification. Well, I am not referring to charging to your driver's license, California driver's license. I'm referring to using that as a source of identification. Did you do that? I believe so. And this was not because you lost your original California driver's license, but because you obtained a new one or a renewal of your own. Is that correct? Yes. And you had that one at the time that you purchased the Jeep. I don't independently remember whether I did or didn't. Do you remember the first time that you were able to use that new or renewed California driver's license as proof of identification? No, I don't. Did you also make an offer on a $1.1 million property? I think it was 1.5. So he's so honest, he corrects him and says it was actually more than that. And where was that property located? In Marina Del Rey. What type of residence was that? It was a 4-bedroom home. And was that to be for you alone? No, it would be for my brother, myself, and my grandmother. Where did Grandma go after they got arrested? Where'd she go to live? Where was she living? I don't even know, but that's so cool that they were going to live with Grandma. Did you also go on vacations? Yes. Where did you go on vacations? We went to Mexico. Cancun? Yes. Where else? I went to New Jersey. Well, that wouldn't be considered a vacation. Lake Tahoe. And did you spend money gambling in Tahoe? Yes, I did. How much money did you spend in gambling? Several thousand, many thousand. And you had to borrow money from Mark Slotkin because of your gambling losses in Tahoe. Yes. Did you go on any other vacations? I know that I went with my Uncle Brian to Colorado. Skiing in Aspen? Yes. Any others? Not that I remember at this moment. Did you also put down $29,000 deposit on a $990,000 Marina City condo? Right. I was trying to get a place, buy home. We didn't know uh, what to buy or whether to rent. We ended up renting. I placed a down on a 2-bedroom condominium, 2-bedroom apartment, or whatever it was at Marina City Club. Who was going to live there? My brother was primarily going to live there. The second bedroom was small. It had three bedrooms. That's right. The second bedroom was small and the third bedroom was small. And I felt that my grandmother, myself, it was just impractical, and eventually convinced Lyle that it was impractical for three of us to live there, and he didn't buy it. Was it after that that you made the offer on the $1.5 million home? Right. And during the same period of time, were there some residences, three residences in Princeton that you and your brother had some interest in? I know that there was the condominium that my parents had begun purchasing that we wanted to have, basically, because early on we wanted to live in Princeton and go to the university there, and so we wanted to make sure that was bought, so we would have a home there in Princeton, and it was up in the air whether or not we would live in Princeton full time. And then Lyle was considering buying another condominium because we might eventually live there, and then didn't because we weren't going to. Wasn't he interested in purchasing two condominiums in Princeton in addition to the one that your parents had already purchased? Right. The third one was for investment purposes because everyone thought it was such a good buy. They thought it was a steal. The price was low. And so, yes, I don't know whether he actually bought it though. And you also employed Mark Heffernan to be your tennis coach? Yes. And did you pay him in one lump sum up front? No, sir. How did you? How were the payments to be made to Mark Heffernan? A check every 2 weeks, I believe. Yes, that's right. It was arranged that my Aunt Marta from Florida would send him a check every 2 weeks of $2,500 in his employment fee to be our tennis coach. And what was that total fee to be? It was arranged that we would get 50 or 60,000 depending on whether he would get 50 or 60,000 depending on whether Lyle stayed on the full year that first year, and that after the first year in the next September I was seriously considering going to Princeton University and trying to get in there, going back to college, and that there was a clause that said if I did decide to go to college that I wouldn't owe him any further money. Did you also employ a weightlifting coach? No. There was a Nautilus guy at the Nautilus gym that Mark met there and used him for stretching exercises, and he felt that I was very thin so that I could build up some muscle. I don't know how much he was paid, whether I just paid him a check whenever we used him but it was very informal. Did you also employ the services of a holistic doctor? Mark had a lot of techniques, training, going to doctors in terms of getting your physical health checked and exercising that I would pay for whenever he wanted us to go to whoever. He wasn't going to pay for it. Did you also go on a tennis tour to Israel? Yes, I did. That's what I was training to do. Can you tell us who paid for that tennis tour? Well, I did. I paid for everything. And you paid for all of Mark Heffernan's expenses as well? Right. And when you went to the Aspen skiing trip, did you also pay for Mark Heffernan to go along with you? Yes, Mark did go on the skiing trip with us, and I paid his airfare. Whenever I was with Mark, I would generally pay for the meals, and when we were renting a car, I would pay for that. And all the expenses anytime he was with me, I would pay. Is it because the skiing trip was considered part of your training? No, Mark was a professional skier before he was a tennis player, and I don't know whose idea it was to bring him along, but we brought him along. Now, did you also speak to Craig Signorelli about buying a home in Beverly Hills? Objection, Your Honor. All right, let's hold off on that inquiry at this point because we're going to take a recess. But I told the lawyers I wanted to discuss another issue altogether, and we will take some time to do that. So we will take a break now, recess for the day, and we will start up again at 8:30. Don't discuss the matter with anyone. Don't form any final opinions about it. We will resume tomorrow at 8:30. The jury exits, and now we have some arguments outside the presence of the jury. And get used to it because as I went through all of these transcripts for the rest of the trial, there's a lot of arguments outside the presence of the jury about stuff that the defense is fighting to bring in or to exclude, and it everything becomes a battle. If it hasn't been already, now everything's just a battle for the defense when they're in their case in chief. So just keep an eye on that. The court says to the witness, "You may step down." Okay, the jury has left. First, as to the last question, was this one of those to which the defense has objected, or yes, says Ms. Abramson. The court says, "I don't have a list right in front of me to which there was testimony at the first trial of knowledge of such a statement." Mr. Khan says there were statements that the defendant admitted to in the first trial. Ms. Abramson says, "I don't know if that was or not, but I should think before counsel goes into an area of confronting the witness with statements of witnesses that they have not called, that we should be told that we should be told what they're about to do or what conversation they're referring to." What the court has indicated was that if it's contained in the tape recorded conversation on November 29th, since it's on tape, the defendant's voice is on tape, that we may go into that. But if it's not within the tape recorded conversation, the court says, "I think it went beyond that to the testimony of the defendant at the first trial in which he admitted certain statements. It was part of the overall." Ms. Abramson says, "If it was on tape, yes." Court says, "Whether it's on tape or elsewhere. If Signorelli has testified to something that the defendant also admitted that he said to Signorelli." Ms. Abramson says, "But we also want to make sure that the people want to go into matters that the court had previously ruled are not admissible on the tape, such as the screenplay. They always take the position." The court says, "I am not referring to the tape at this point. I am just referring to anything that Signorelli has testified about that the defendant was acknowledging saying. Now, I have also indicated that there should be no questions asked of the defendant regarding matters that have been subject to a ruling before by the court involving Signorelli." Mr. Khan says, "Right, although now we need to address the issue of the remaining statements. The court indicated that the people may be able to go into the additional areas provided that we have Craig Signorelli under subpoena and that we address the legal issues raised by counsel. So we do have Mr. Signorelli under subpoena now, and so we would like to get into additional areas." The court says, "Okay, well, there are two things here. One has to do with questions relating to Signorelli's testimony in the first trial, to which the defendant has made denials in his testimony at the first trial, or other conversations that the defendant had with Signorelli that the defendant has denied in his earlier testimony in the first trial. There were also certain areas that were subject to litigation before the first trial or during the first trial in which the court foreclosed certain inquiry on of the defendant or Signorelli, and that's a separate issue. Now, did you propose to go into those areas or only areas that the defendant was asked about in the first trial and denied making certain statements to Signorelli?" Mr. Khan says, "At this time, I would like to explore all three issues with the court, and that is, first, we have the admission from the defendant from the first trial, which should not be of any dispute since he acknowledged these statements in the first trial. Then we have the denials. We would like to be able to question him concerning those denials. Then there are the remaining matters, that is the screenplay and the admissions to Craig Signorelli concerning the circumstances of the shooting, and we would like to get into those matters in light of the testimony of the defendant in this trial." The court says, "All right. As far as the denials, I equate the admissions to Signorelli regarding the shooting to which the defendant denied making those admissions in the first trial as denials." Mr. Khan says, "Okay." The court says, "I am associating those in that category." Ms. Abramson says, "Except it gets confusing, Your Honor, because Mr. Signorelli made many inconsistent statements about what he was told by the defendant, and then he testified in trial to a particular version of the statement. So I do not believe the people should be entitled to confront defendant Erik Menendez with any statement that appears in a police report that Signorelli didn't actually testify to at trial." The court says, "Well stated, Mr. Levin." And he's being a jackass because Ms. Mr. Levin is obviously doing the questioning, but Ms. Abramson is doing the arguing. She says, I'm arguing this aspect, Your Honor. He says, I got that impression. What a jerk. I really don't like him. She says, I have argued it before. He says, let me ask the people, did you intend to go beyond Signorelli's testimony in the first trial on these issues? Mr. Khan says, we could limit it to his testimony from the trial. Court says, okay, all right. So that is the people's offer to inquire of the defendant regarding statements he made to Signorelli as testified by Signorelli in the first trial and denied by the defendant in the first trial. Ms. Abramson says, we'd like to see the proof of service that he's under subpoena. We've never seen it. The court says, I think it's appropriate. Do you have proof of service as to Signorelli? All right. It shouldn't take too long to review that, Mr. Levin. Mr. Levin says, I read slow, Your Honor. I don't recognize Mr. Signorelli's handwriting. The court says, okay, let's let the other counsel see it. Mr. Levin says, the record should show that Mr. Gessler is spending more time than I did on it. The court says, well, he's sharing it with Ms. Towery, though. They are reading every other word. Ms. Abramson says, Ms. Towery reminds us that she is now an expert about declarations under penalty of perjury, and she says that the form of that subpoena is improper since there is no declaration under penalty of perjury by the server of the subpoena. Hmm. Interesting. The subpoena is not valid or something. The court says, well, the issue is whether or not the court would issue a body attachment if Mr. Signorelli didn't appear. Ms. Abramson says, well, he is placed on a 2-hour call under the terms of that subpoena, so I am not sure how that works. The court says, all right, did counsel wish to argue the fact that Mr. Signorelli has been served with a subpoena or go into the merit of your argument? Ms. Abramson says, no, we're not going to challenge based on the service of the subpoena. Court says, do you have anything else to argue other than what you put in your written materials and previously said on the statement? Mr. Gessler says, yes. I would just repeat the last words. The people have not expressed an intention to call Craig Signorelli, even though they have him under subpoena. I think it's even more prosecutorial misconduct under the process clause to submit or to subpoena a witness without the intention of calling him, particularly where they feel that they will not call him that witness because his credibility was so hurt or destroyed in the first trial, and then to ask questions of a co-defendant on the stand based on that, did you tell Craig Signorelli? Unless there is an expressed intent to call that witness to impeach Erik Menendez, should he say no? The reasons are the same as those expressed in People versus Low Signo, that once you ask a witness, did you tell a certain party, even on a given date, a certain answer, that one or more of the jurors is almost certain to believe that they had a belief that that event occurred and for whatever reason couldn't call the witness rather than didn't call the witness. And the jurors do not get to see the factors that went into the credibility determination, not only by the first jury, but by the or by the district attorneys as well. So basically, the district attorneys have a subpoena for Craig, but they have no intention of calling Craig. Hold on, I need a fan. It is hot in here. That's better. All right. So basically, the prosecutor has a subpoena for Craig, has no intentions of calling Craig. Craig has basically been completely discredited from trial one. He looked like a complete fool and a liar, and his testimony was very inconsistent. So, oh boy, my computer's going to die. Hold on one second. We were plugged in, but we got unplugged. There we go. Okay. So, that in and of itself is having this subpoena for this witness that you have no intention of calling is bad enough. But then when you're going to have Erik on the stand, the defendant on the stand, you're going to basically I don't know what's going on with this fan. Why is it being weird? Hold on one second. And so basically the defense is saying they shouldn't be able to call, or they shouldn't be able to question Erik without calling Craig Signorelli to the stand, which they apparently have no intention of doing. So that's the big argument there. And then he goes on to say, I think that I would ask the court to review one more case that is not straight on Los Signo, but contains the thoughts of Los Signo. That's People versus Bell, 49, California something. Whoops, I didn't mean to do that. California something something. I don't know. Whatever. The discussion is continued at pages 532 through 532 through 534, and they talk about the fact that the Supreme Court has not directly talked about when conduct like this or misconduct like this becomes a due process violation, except in Douglas versus Alabama, and they use that as a measuring rod. And basically, how close is the conduct of the district attorney in a given situation to that in Douglas versus Alabama? I am sure that the court recalls in Douglas they had a co-defendant and they read him basically a purported statement made to a police officer and did you say this and so forth, and there was no confrontation available. They found that that was a violation of due process in Douglas. I think what the prosecution is intending to do in this case, if they are not going to promise to call Craig Signorelli to impeach, is the very same process. It's innuendo, it's inference to the jury that such a statement exists, or they would not be asking the detailed questions that they are without actually proving it up. So basically, you know how the court always says the questions are not testimony, the answers are testimony. Well, basically, you hear the question and you think, well, they're asking that question for a specific reason. There must be evidence or something behind that. So there's the inference that when you're asking the question, did you say this to Craig, that it's true that was said to Craig, and you're not calling Craig to confront him about it. So you're asking Erik's side but not giving the defense a chance to ask Craig about that statement. You know what I'm saying? So that's an issue. Court says, okay, let me look at Bell, and I will be right back. And do you have any cases you wanted to cite other than what you already cited? No, Your Honor, says Mr. Khan. The court says, take a 5-minute break. They take a recess and they come back. The court says, okay, in the trial, we have everybody present without the jury. Again, I've read the case cited by the defense, People versus Bell. Any response by the prosecution? Ms. Nahara says, Your Honor, just briefly, it doesn't appear that Bell, in the section cited by counsel, really applies to the fact situation here. In Bell, apparently, there were statements that were elicited from the informant that they, both sides, stipulated would not be called, which is not the case here. Here, the whole issue hinges on whether or not there is a likelihood that the people can call this witness, and this witness is available to the people, with which is our case. We have shown that he is, and in Bell, clearly he wasn't, because the people had already stipulated in the Bell case that they would not be calling this informant. Mr. Gessler says, I fail to see that likelihood can call, Your Honor, solves the problem here, although this was an expert witness being cross-examined rather than a co-defendant. I think the principle is the same, particularly at page 532, where they talk about deliberate asking of questions calling for inadmissible and prejudicial answers is misconduct. And at 8C, at the bottom of the page, it also appears that the prosecutor engaged in deliberate attempt to put inadmissible or prejudicial evidence before the jury. And again, they meet the problem at 533. In that case, it was a witness who was not available for cross-examination. The misconduct was particularly egregious here because the prosecutor put before the jury the hearsay statement of a person who was not available for cross-examination, and that statement suggested that defendant not only possessed a weapon like that believed to have been used by the murderer, which was the issue in that particular case. And then they go on and make their analogy to Douglas versus Alabama. In this case, Your Honor, I think the whole answer is whether or not the people are truly going to call Craig Signorelli. If, in fact, the answer that Erik Menendez gives to the questions are consistent with those to the first trial, that they are denials, and if they are not going to, that this is misconduct of the worst kind. It's worse than a witness who is not available to them, where through no fault of their own, they can't prove up the fact. Even that is misconduct. But it is worse misconduct when they don't call a witness because they don't want his credibility tested in front of the jury. That's really the only reason why they don't want to call him. The court says, let me inquire of the prosecution. Have you made a decision as to whether you will or will not call Signorelli at this point? No, we have not, Your Honor. Of course, because you know they're not going to want to. And when did you anticipate making that decision? Probably when we get to the rebuttal part of our case at the end of the defense. All right, let me put this in perspective here. Before the trial began, there were hearings on whether or not this would be a trial with both defendants or separate trials. One of the issues involved in that litigation was potential issues of statements relating to statements made by one defendant outside the presence of the other defendant that the prosecution would seek to introduce. There were objections, and specifically regarding Mr. Signorelli and his testimony, objections by the defendant Lyle Menendez. The defendant Lyle objected to testimony from Mr. Signorelli of statements made by Erik to Signorelli, and at the time the issue arose, the court ruled that the matter could not be introduced in the people's case in chief, these statements, because the defendant, Lyle, would be denied the right of confrontation. And the person who would be the declarant in that situation was the defendant, Erik. He is currently on the witness stand being cross examined and is available for confrontation purposes to the defendant, Lyle. I take it from your argument here, Mr. Gessler, if the prosecution did not ask questions of the defendant, Erik Menendez, about what Mr. Signorelli alleges, Erik Menendez said to him, you would have no objections and your client would waive any so-called Oranda Bruton objections if the prosecution, in its rebuttal, were to call Craig Signorelli to testify that subject. That is correct, Your Honor. Is that what you're saying? Says the court. If they are going to call Craig Signorelli for the specific purpose of impeachment on the very questions to which they do not like Erik Menendez's answers, then I would waive Oranda Bruton objections that we had at the start of their case in chief before Erik Menendez testified. My objection is, the court says, even though Erik Menendez would be unavailable to you as a witness to refute these statements that he is alleged to have made, is that what you're saying? Mr. Gessler says, well, the point is, Your Honor, if he has basically denied the characterization, in other words, let's say the prosecution asks him a certain question. Asks who, says the court. Mr. Gessler says, did your brother tell you shoot mom? Let's say that's one of the questions that was in dispute when we first started this before the trial, and without saying, did you tell Craig Signorelli this, he simply said, no, my brother did not tell me that. Then, if you're going to put Craig Signorelli on to say, yes, he did too, tell me that, or yes, he told me that as a prior statement, I think that would be willing to forego on Lyle Menendez, the Bruton Oranda. It's really what is, I don't understand. I don't know what the Bruton Oranda thing is. It's really what is the foundation under the evidence code in order to put in a prior inconsistent statement that we're talking about here that the people would have to meet in general cases if there was a one defendant case. The court says, except this is a co-defendant who would be unavailable to you as a witness, at least that is the offer here, that you couldn't call Erik Menendez to testify, and therefore Lyle Menendez would be denied the right of confrontation. Mr. Gessler says, that part is true, Your Honor. On the other hand, if we have this veiled reference or specific reference, did you tell Craig Signorelli the following, to which Erik Menendez says, no, I did not. I have a worse problem of confrontation. Unless then Craig Signorelli comes in and says, yes, he did tell me that. I have a confrontation problem either way, but the worse confrontation problem. The court says, well, you don't have a confrontation problem at all if Erik Menendez is confronted with the prior statements allegedly made by him to Signorelli, that therefore your client has the opportunity of seeing Erik Menendez testify and hearing his responses and is there to confront, and you can question Erik Menendez about them, the whole subject. Mr. Gessler says, what's to question? He's saying, no, I didn't. There's nothing to question. My problem is I don't get to question Craig Signorelli, nor does the jury get to see him unless the prosecution calls him. The court just made the statement that it's better because they don't get, or like it's a hindrance to the state because the jury sees Eric and not Signorelli. That's literally what he just said in this argument. And that's insane because you should be able to confront the person that is telling you or that is saying that you said something and you're like, no, I didn't. You should be able to confront that person and they're not calling them. Um, where was I? I have the same problem. This is Mr. Gessler continuing on. I have the same problem that they had in Bell when they did this with Mr. Schomer. Dr. Schomer said, that report didn't make any difference to me, but they still got it in by inference to the jury who said there was an informant out there who said he had seen the gun before the day of the crime or a day earlier, but at any rate at a relevant time. Problem, there was not the problem there was not that Dr. Schomer could not be cross examined. The problem was that the so called informant who was being put on as a ghost witness could not be cross examined. Court says, well, in Bell, he was unavailable. Supposedly, says Mr. Gessler, but let's say he was unavailable. To me, as I said before, it's worse than that. He is available, but chosen not to be called by the prosecution for whatever tactical reasons they have of not wanting to put his credibility in front of the jury. I think that's a worse Sixth Amendment problem where they're making a tactical choice not to call a witness, but to put it on by innuendo than it is where the witness was never available to begin with. Now we're talking about a deliberate prosecutorial decision to forego putting on an available witness whose demeanor and credibility could be determined by the trier of fact because they don't want to take that risk and feel that they can accomplish the same thing by innuendo. And that's what Douglas versus Alabama talks about and the due process right. And I think that's what Bell and Lo Signo are talking about in the state court. Problem is the same. The harm to Lyle Menendez is certainly the same. In fact, it's worse. The court says, all right, okay, anything further from anybody? What do you propose to do? Ask Mr. Menendez, did you say these things to Signorelli, or what is it you're proposing to do? Mr. Khan says, propose to ask it just as the court suggested. Did you tell Craig Signorelli the following? Ms. Abramson says, I'd like to know what the followings are, Your Honor. There are still a bunch of areas that the court had previously ruled he couldn't get into. Court said this is confined to his testimony from the first trial. Correct, says Mr. Khan. All right, says the court. In this matter, I've looked at all the cases cited, and starting with Lo Signo, which was a notable case in its own right, a case of local interest. The key witness was Mickey Cohen, and one of the prosecutors was former District Attorney Mr. Bush. And the issue really in that case was bad faith, that the questions asked by the prosecution were asked of Mickey Cohen in bad faith, and that is the basis of the Lo Signo holding. I have reviewed the Bell case and Douglas versus Alabama. Those are cases where the witness was unavailable. Blankington, People versus Blankington is another case. That was an Aranda situation. The non testifying defendant's statements were used to impeach the defendant. A mistrial was declared as to the declarant, but not as to the other defendant. In that situation, the court found prejudice, but again, in that situation, the declarant was unavailable as a witness. Here, it has been established that Mr. Signorelli is available as a witness, and there is no requirement that the prosecution make a binding decision at this stage as to whether they intend to call Signorelli, and they are entitled to evaluate the case based upon the defendant's responses and the totality of the evidence presented during the defense phase before making a decision on the subject. How many of you knew he was going to rule this way? I did. The question is whether or not at this stage they are acting in good faith or bad faith when asking such questions. And it's my view that the witness is available. The people have established their good faith of subpoenaing him, placing him on call, and therefore, my dog keeps moving my thing. Sorry. Okay. Um, where was I? The question is whether or not at this stage they are acting in good or bad faith. It's my view that the witness is available. The people have established their good faith by subpoenaing him, placing him on call, and therefore I find there is good faith in asking the questions of the defendant regarding statements he allegedly made to a witness who is available to testify. Of course. And the people ultimately will make a decision as to whether or not to call Mr. Signorelli, I bet they won't, as a witness based upon their evaluation of the case at the appropriate time. That's a decision of trial strategy that they aren't required to make a binding decision on at that point. However, at the same time, the court is concerned that the jury might get the impression that Mr. Signorelli previously testified under oath to these events, which would give greater weight to the questions than the questions are entitled to. We had some questions of the defendant regarding whether he was in court and watched testimony of other witnesses, and do you agree or disagree with it, and things of that nature. I don't think that would be appropriate questioning in the cross examination of Eric regarding any statements he made to Mr. Signorelli as testified by Signorelli in the first trial. Any such questioning should not refer in any way to the fact that Mr. Signorelli testified in the first trial, as I said, because to it, if it turns out that Mr. Signorelli is not called to testify, what? So you're hiding it from the jury that he testified in the first trial and the eh, to to save the prosecution from having to call him? This is insane. But this is appropriate cross examination to test the credibility of the witness, the defendant, and to see whether what his answers are in regard to these questions. And the jury is entitled to evaluate his answers only in light of what he testifies to and with the understanding and the instruction of the court that is prejudicial to either defendant. And oh, wait, I skipped a line. Sorry. With the instruction of the court that these questions are not evidence. And I don't find that this is prejudicial to either defendant and does not deny either defendant the right of confrontation because, again, the declarant is the defendant, Erik Menendez, not Mr. Signorelli. And that is the ruling of this court on this particular subject. You wanted some time to talk about the screenplay. In regard to that, certain additional evidence has been offered here in this trial. First of all, we had the testimony of the rights, which was not presented in the first trial, and the testimony of Erik Menendez regarding not knowing what the meaning of the word probate was, not knowing what the word or function was of an executor. I have no recollection whatsoever as to whether or not those matters are referred to in the so called screenplays, but I would invite the parties, both sides, rather than shooting from the hip, to evaluate whether it is the people intend to offer in regard to those screenplays by way of the cross examination in light of the testimony of the rights, in light of the defendant's responses to those issues that I just raised, and any other matters that have arisen during the course of this trial, so that the court will have the benefit of your guidance and evaluation of the material. I really haven't. Oh my God, my dog keeps bumping everything. Sorry. He keeps messing my camera up. We're almost done here. So I'm trying to get through it, but as he's moving around, but he's not settling it back down. Where was I? Rather than shooting from the hip, evaluate whatever it is that the people intend to offer in regard to those screenplays by way of cross examination in light of the testimony of the rights, in light of the defendant's responses to those issues that I just raised, and any other matters that have arisen during the course of this trial. So he basically just gave the prosecution the go ahead as to this is how you can get in the screenplay, basically. Um, by bringing in the rights. So the court will have the benefit of your guidance and evaluation of the material. I really haven't looked at it with these issues in mind and would like the parties to do that before we discuss it further. Ms. Abramson says, Your Honor, I can tell the court. The court says, I don't want to hear argument right now. I want everyone to be in the same position so that they can respond. Ms. Abramson says, I want to give you some facts. Don't respond, says the court. I want to have everybody in the same position after having reviewed the material again so we can evaluate it at that point so we can do it tomorrow. As far as the other issue, you wanted some time to talk about the former testimony issue. Ms. Abramson says, well, while we are dealing with Lo Signo, though, why don't we deal with the Ozeal offer as well, since it's the same thing? The court says, I don't know if the people want to do that. You wanted some time to talk about the former testimony issue. Ms. Abramson says, I would like to inquire of the court whether or not the people have met the requirement to make application to this court with respect to an act of state offer as to Dr. Ozeal. They have. Ms. Abramson says, it would have been nice if we were given a copy of those documents. The court says, well, they are not required to do that. An application was made and it was signed by another judge, and then another application was made and it was signed. As far as how it was processed in another state, I have no knowledge of that. The offer has been made that there will be no reference made to Ozeal beyond that which has been admitted by the defendant until there is such a hearing and we have held in regard to Signorelli. All right. What about this former testimony matter? Ms. Abramson says, okay, the issue is, Your Honor, the people request in their response, besides their objections to what portions may be shown, but they're requesting an opportunity to see our offer by way of tape. We want the court to rule on our motion in limine with respect to testimony of the co-defendant and rule on the people's efforts to decide what portions of those tapes we get to play so that we can then and to have the court decide what impeachment the people may what would be appropriate impeachment under 1202 based on whatever it is that the people offer they want to use for impeachment so we can make a decision about whether or not we are going to proceed this way and more importantly on a timely basis so that we can come up with these edited tapes and turn them over to the people so that they can see them. It's a matter not only of time, but also of money. We don't want to spend the money, the non existent money. We don't want to spend our money on making duplicates of this if ultimately the courts rule in such a way that strategically and tactically we decide not to go forward. We do have one copy of the material where all sidebars, objections sustained, fade outside of the camera away from the witness. All of that has been edited out. So it does look like a deposition and it runs about 3.5 days. All the testimony collapses into about 3.5 court days. Court says, okay, and you have proposed in your moving papers to redact certain portions of that material that you regard as relevant. Ms. Abramson says two things, Your Honor, irrelevant or opening doors that don't necessarily need to be opened. The two things we are offering to redact is all of the testimony concerning the meetings with Dr. Ozeal on October 31st and November 2nd, and any testimony by Lyle Menendez concerning his mother's threats to poison the family. The court says, those are the only things you propose to remove? Yes, those are the only things we propose to remove. All of the testimony about the actual shootings we were going to leave in, and all of the, as the court may recall, the only real cross examination of him had to do with the shootings. All of that. We weren't going to try to redact that because we believe under 356, under the same subject matter, basically, the people would be entitled to play that anyway. So we are prepared to do that. Okay, says the court. And the people object to certain portions of the defendant's testimony from the first trial, is that correct? That's correct, Your Honor, says Ms. Nahara. The court says, and these were objections on grounds of relevancy and 352 of the evidence code? Ms. Nahara says, that is correct, Your Honor. Basically, that we had discussed before the defendant, Eric, took the stand, there were a great many issues that we felt that the defendant should not be allowed to testify to, and I believe at that time the court pointed out that we should wait until he takes the stand and makes the timely objections. I think part of the problem here is that counsel is going on the assumption that we should go, that we are going to go. The court has already decided we're going to go to videotapes, And I think the first hurdle we have to discuss here is if the court thinks that going with videotapes is the appropriate way, considering the fact there is a substantial amount that will have to be redacted. The court says, all right, I read the documents filed by the prosecution on the 22nd, as well as the materials filed by the defendant, Erik Menendez. The people's position is basically that they can find no authority for the proposition that the defendant, Erik Menendez, cannot put forward the testimony of the co-defendant from the first trial as former testimony that was subject to cross-examination, but they do raise certain issues. One of them has to do with the ruling on objections. And in analyzing, one has to look at who is offering the evidence. It's not being offered by Lyle, it's being offered by Erik. Therefore, the examination of Lyle Menendez in the first trial would not be admissible to the same extent if objected to on grounds of relevancy as it was when offered by Lyle Menendez in his own defense in the first trial. Certainly, the state of mind of Lyle Menendez and events of his childhood and things of that nature, depending on what it was he testified to, would not be relevant to Erik Menendez. Much of the testimony of Lyle Menendez I can envision would be subject to objections by the prosecution on the grounds of relevancy, and it would be properly sustained because this is testimony offered by Erik Menendez for certain limited purposes, not testimony offered by Lyle Menendez to support his defense. Therefore, my initial reaction to that would be the need for substantial hearings on issues of relevancy and admissibility, and hearings under Section 352 of the Evidence Code as to the admissibility of what evidence from the first trial would be admissible in the retrial. Those hearings, in my view, would be best be conducted in the same way as they were during the testimony of Erik Menendez, by the questions being asked and the court ruling as the grounds of relevancy and 352, or whatever other objections is made that is not made as to the form of the question, which would not be appropriate, but as to the ground of relevance under 352, or other issues that are not addressed as objections to the form of the question. And the court does not intend to get into an editing process of watching the videotape and ruling in advance to every question and every answer beforehand, and it certainly wouldn't be feasible to have the tape being played to the jury and then rule as the matter is being put forth. Therefore, it seems to me that the only way to deal with this would be to have the reporter read back the testimony of Lyle Menendez and questions asked, objections made, and rulings made, and then the matter going to the next question if the objection is sustained. So they're going to have the court reporter read it instead of playing videotape from the first trial. As far as the timing of this as to when the defendant, Erik Menendez, would present the evidence, it seems to me that the issue of unavailability is not finally resolved until the defendant, Lyle, announces that he is resting and has no further witnesses to call. Until he does that, the court is not in a position to say that truly Lyle Menendez is unavailable as a witness and to make such a finding, because the defense has already indicated the defense for Lyle Menendez doesn't know. They haven't made a decision yet as to whether or not Lyle will be a witness. And certainly, I am not going to be put in a position, I don't think the jury should be put in a position of having all of Lyle Menendez or portions of Lyle's testimony from the first trial presented to the jury, and then Lyle Menendez turning around and taking the witness stand and testifying on his own behalf. Ms. Abramson says, Your Honor, could I be heard before I get to each and every potential here, just to the first issue? The court is apparently ruling that we can't use videotape in order to present this testimony on the notion that it's too cumbersome. Court says it's not a notion that that's the court's belief. Everything that you disagree with is a notion, so let's characterize it some other way. He is such an asshole. Ms. Abramson says the court's belief that it would be too cumbersome. Well, the reason I used the word notion is because I don't understand how playing the testimony of Lyle Menendez is in any way analogous to presenting the live testimony of Erik Menendez. The difference being the people know precisely what it is that's on that tape and in those transcripts. Therefore, the notion that the only And I only use notion in the sense of idea. The notion that we would have to stop and object because you don't know what's coming and you don't know what the people are going to ask does not apply when all I would be offering is what's already memorialized. There can be no change, there can be no new answer. We don't have magic built into those videotapes. That's very different than the situation where they don't know and the court doesn't know precisely what Erik Menendez is going to be asked on direct in this trial, and therefore, rather than to anticipate all of the possible things and make relevancy rulings in advance, the court rules properly that those rulings should be dealt with and those objections should be made as he testifies. But we are not in the same position vis a vis the previous testimony of Lyle. If there are areas that the people wish to object to that previous testimony, we can argue those objections based on the transcripts because we do have them, and then edit the tapes to conform to whatever the court rules is admissible. So if the state has an objection to what's on the tape, just tell us and we can edit the tape. But to say that we can't use videotape, which is the only way we can present demeanor evidence, since neither of the reporters look or sound like Lyle Menendez, to eliminate all chance of presenting demeanor evidence, I think is going too far in the name of efficiency. The fact is, hold on one second. Continuing on, the fact is, we can efficiently deal with it in advance, the people's specific relevancy objections and their theories, and we can argue what our theories are of relevance are, even for the events of his childhood. I would remind the court may well remember that Lyle Menendez's entire direct took less than 3 days in the first trial, and his cross examination, which took 6 days, was solely about the homicide. So there really isn't all that much by way of time consuming information. The court says, well, there was a lot. There was all his childhood and the allegations of sexual abuse, all of which would be irrelevant. He does not want that coming in. He says the sexual abuse stuff is irrelevant. So he doesn't want that coming in. That's probably why they're fighting this. Well, I don't agree. They are irrelevant, says Ms. Abramson. I think the character of Mr. Menendez as a sex molester is the one area of character that we should be able to prove. And I recall in rereading previous rulings that the court did not rule out all aspects of character evidence concerning the alleged victims from coming in. Beyond that, his violent tendencies, which Lyle Menendez testified to in some respects, would come in. I also believe that Lyle testified to observing things happening to his brother, which we believe are relevant. I don't believe that we have yet settled the scope of Erik Menendez's testimony because we believe through cross examination the people have gotten into areas that would allow us now to ask on redirect certain questions that the court sustained objections to on direct. So I'm not sure the scope here of the defense evidence has been totally delineated, and therefore we feel there are significant portions of Lyle's testimony, previous testimony, that have been made relevant through cross-examination where were relevant even before that and are relevant to corroborate Erik Menendez. I can recall some things that he testified to that I would agree are of marginal relevance, and I'd be happy to take them out if they mattered that much. But basically, I think his description of Eric's statement at the beginning of his parents' is relevant now and may go a long way to explain why it is Erik Menendez can only remember a smile as the only loving gesture his mother ever made because it was the only loving gesture his mother ever made. And I think issues such as those have been opened up by cross-examination and that issues such as those are at the core of the Lyle Menendez previous testimony. And I am concerned that the court keep open the possibility of a videotape presentation, assuming that because we can do all the determination of relevance based on transcripts and the court need not view the actual tapes in order to make those determinations. With respect to the other issue, the timing issue, I think that I should be entitled to conclude the evidence, or that we should be entitled to conclude the evidence of Eric's defense as to us. Lyle Menendez is always unavailable. We can never call him. The court says, okay, I disagree with that. If it turned out that Lyle Menendez was a witness called by the defense for Lyle Menendez, then he clearly is available, and I don't know that until the case is over. And my view is until that situation arises, I would not be prepared to rule that he is unavailable as a witness. And secondly, my view at this stage is that in order to rule on these objections by the prosecution, and there are obviously debates as to what the ruling should be, we have already heard your position as to some of them. The only appropriate way of dealing with that is, and the most efficient way of doing it is to do it by by questions being asked and the answers or rulings being made if there is objections made. And otherwise, we would end up with literally days upon days of hearing about redacting the tapes and whether this redaction was enough or not enough. And we would go on and on and on. We are not in a situation where all of the testimony is being offered, only portions of it, and my view is that the only efficient way, as the most effective use of the court time and the time of the counsel and the time of the jury is to do it by reading the transcript. And the Ms. Abramson says, I don't understand why the people can't submit their objections in writing and have the court rule on those objections. The court says, as I said, then we would get into debates about editing the tape. Was this all taken out? Wasn't it taken out? And after we watch the whole tape and make sure that it's all right, and then watch it again, and it would take days upon days. Ms. Abramson says, if they're right, Your Honor, it's going to be a very short tape. I mean, if they're right. The court says, if it was a short tape, we would spend days upon days editing it down. That's the way it would work. He's just not, these are not good responses because it's going to take days and days upon end. No, you just don't want the tape coming in. Ms. Abramson says, to rule out any chance to put on accurate demeanor evidence based upon those kinds of considerations, we are trying to get this resolved now. The court is saying we won't be unavailable, or the court is saying he won't be unavailable until the end. I think that gives us about 6 weeks to work on this, if that's true. Court says yes, 6 weeks of court time, which we are not going to use for that purpose. We are going to use it to present evidence and witnesses for the jury. This jury has been here long enough. This judge is an ass. These are not proper legal responses. He just wants to argue with Ms. Abramson. He doesn't want to give the defense an inch. Ms. Abramson says, I'm sure in 6 weeks we could get the evidence just perfect, and they have about 4 law clerks who could watch them. The court says it is not 4 law clerks who will be ruling upon these issues. It is me, and it would be done in open court, and it is my view it would be too time-consuming to do that. Therefore, that's how I look at it. Anything else at this point, Ms. Abramson says, I would like to go on and get some indication about the scope of the 1202 impeachment that the court would allow. The court says, let's do that then tomorrow. It might be that we will have to wait until we have concluded the cross-examination of Erik, when some of the issues will be more clarified. Ms. Abramson says, fine. They took a recess until the following day. Judge Weisberg just loves to argue with Ms. Abramson. Like, loves it, I really feel. We saw it in person, or well, not in person, but we saw it face to face when we watched the first trial, and boy, did they have some head-to-heads. You can feel the tension when they talk. They disagree about a lot of things. I think it's because he might be biased, just a little. What do you guys think? Is Judge Stanley Weisberg biased in this case? Let me know in the comments below, and I will see you guys in the next one. Thank you so much for watching. Take care. Bye now. That's the end of this Trial Transcripts Exposed. Thanks for following along with me. Like if you want more, subscribe, and let me know what you think in the comments below. See you next time.